Hello, fellow internet. Hello, fellow people. Hello, everybody. I'm netpoet, in case you didn't know, and it's shocking to see all of you here, especially because I don't seem to be able to find a topic that no one is interested in. No, but on a more serious note, apart from actually, thank you for coming here. I have a couple of disclaimers to make. The first one is this is almost entirely AI created, and I'm trying this for the first time. It's a presentation in HTML, and I just found out yesterday that this is a thing that you could do. Of course, I edited some of the stuff, obviously, and but this is the first time I'm trying a presentation in HTML, so if nothing works, then it's all on me. Secondly, the talk that I'm about to give to you and I'd like to discuss with you is more meta, if you will, than the ones I used to give. So before, I used to take a more or less specific aspect of law and discuss stuff, and this is more high level to give you an idea what's going on in the EU, legal-wise, legislation-wise, and also, there's tons of stuff to discuss, but what I'm trying to say is I would be grateful for feedback. It can be one-to-one, I'll be around. If you get more out of this talk or less than before, if you've attended previous seminars, obviously. So I'm always eager to find out what to talk about that could interest you. And so this year I'm going more meta, more high level as to what is going on in the EU, ideas that the EU Commission has had. I'll try to sprinkle in a little opinion and attitude every now and then. Let's not spill our drink. And so today I would like to talk about the Digital Omnibus, which is what? Like, hands up if you have any idea what that is. Okay, I see some. All right. It's horrible in the sense that it's buzzwordy as fuck. But still, it does matter to a lot of us, I would think, and I'm trying to give you some idea how and why and when, or what aspects are considered, if it does. So we're going to, as we go more high level than before, I'm going to go past a few areas of law that it concerns. I'll give more context in a second. And one thing that I would also like to figure out first is, please raise your hand if you think that EU legislation is too complicated. Okay, some. Fewer hands than I thought, but okay, fair, I'll take it. Full disclosure, I think a lot of stuff is too complicated. And I don't think it's because I don't understand. I just think it's impractical on many levels. So let's go into why that is. So this last disclaimer comment is also for you. Usually what I do is when I go through PowerPoint, I try to highlight and fade in all the abstracts one by one, or the paragraphs, I should say, one by one, so you never have the conflict of wondering whether to listen to me or read it. So I have not been able to do that in this HTML file, so you'll see the entire page at once, like each page. But worry not, I'll guide you through all of this, and you can always say stop or break, and I'll go back and stuff. Okay. So let's see how that works. So what is the Digital Omnibus to begin with? And it's the bus The bus metaphor isn't so bad because it actually transports a variety of aspects of law, you could say. I wouldn't say laws, but it does affect a variety of already existing laws. So it's nothing, it's not, don't think of it as a new operating system. Think of it more as an attempt of the EU Commission to simplify stuff that's already there. That's why I asked whether you thought it's too complicated. So, but by the way, is this legible from back there? Okay, okay. So what the EU Commission has been trying to do, what the EU overall has been trying to do is recently, apart from pushing more and more legal acts into it, like the cyber resilience and digital operations resilience and all sorts of information security stuff, everything digital, cyber, you get the idea. They noticed that stuff has become too complicated because there are several acts that sound the same. We will see, for example, the Data Act in this talk. We will see the Data Governance Act, thinking, are they related? Are they siblings? Are they inbred? Who knows? So what we've tried, or what the EU has been trying to do, is simplifying stuff that is overlapping, and that's causing a lot of confusion, has been causing a lot of confusion in companies especially. So if you work for one of these companies, this might affect you as well. I will also give you a few other ideas in this talk when and why you might find any of this interesting. So the bus is actually rather a series of proposals. This is not in force yet, so stuff might change. But the sort of general path in which it's going has been laid out, so I think it's concrete enough so that we can talk about this. So mainly in November last year, the EU Commission published a series of linked proposals that is now called, or there are more, but the one from November is called Omnibus 7 on Digital. It's just the title. And if you feel compelled to look this up, these will be the numbers that you can look for. But you can just look up Digital Omnibus 7 and you'll find all this there. So what, of course, the EU always does, and it's a matter of debate, I think, is they say, oh, we need to cut some red tape, make stuff easier, and also help EU competitiveness. That is something that I've heard various times before, from when the GDPR came. A lot of acts come with the implied, sometimes very explicit promise of making stuff easier and the EU more competitive. Full stop. So as the digital omnibus, or is the omnibus on digital, what it has to cover, obviously, is everything that you would probably think of, especially I can't do that here, and I have no laser pointer. Why is that? So it covers aspects of AI, a lot of aspects of that, actually. It covers some cybersecurity. It covers some GDPR, and I'm very happy for that. I'm very happy that the GDPR is now finally very likely to be amended, let's say, or concretized, if you will. And on a very simple side note, the e-privacy part is also going to be affected. And something tells me that this is the part where every one of you is going to say, finally, thank you. Sonia, thank you. Thank you. Beep, 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 beep. Thank you. Okay. Of course, since it's not connected, stick it in. You have now been hacked. It's not working. What did I do? Page up, page down. Oh, shit. You're right. I'll take it out. It's too late anyway. Okay, so yeah, so this is a general overview of what the Digital Omnibus is or is supposed to do. Now, OD, it's supposed to be DL. See what happens when you are short of time. The Digital Omnibus is still in the making, so it's not, as I said, it's not actual law yet. But to just give you a quick idea, I could say, and I'm speaking in tongues here, but it's see how much I need help if this is wrong. So we have already a branch, but it's not merged yet. So generally what happens is the Commission, the EU Commission, is the person that, or the organ in the EU that will come up with the proposals. Those are the people that make the law, if you will. They can't make the law happen, but they can initiate and propose and negotiate stuff. Then the Parliament and the Council have already taken positions, but the end state is still open. They're still negotiating. Just, I don't know, hands up if you've ever heard or read or seen actual negotiations in the EU Parliament or in the Council happen? Okay, I see one hand, two. Okay. Like the full translation regimes, it's extremely cumbersome. It takes a long time. So they're not done yet. As of pretty much now, they're supposed to be finishing it, but at this point they're still not doing it, or they haven't finished yet. And there are a couple of positions that are especially debated, or especially intensely debated, especially the privacy-heavy stuff. I'll look into an aspect of that later, and AI-heavy stuff. Obviously, AI is under a lot of scrutiny at this point. So, which laws does it affect? Roughly speaking, it affects a lot of laws, and we don't have time for that. But I'm thinking that there are 3 laws that we want to look at because they might affect you in your work or in your personal life, one way or another. So mainly, the GDPR has been a target of, or object of, some clarifications and simplifications. In my current job, I am the data protection officer for the EU group of my employer, and I can tell you that some stuff it happens all the time, and I'm very glad that here there are some alleviations made possible, so that, for example, I'll go into that in a second, that you don't have to report almost every and any incident anymore to the supervisory authorities, so that the hurdle is raised a little. Then the AI Act gets a few amendments, and I'll go into that as well. And finally, and this is where probably all of us are going to say, oh, thank you, is the e-privacy stuff. Because the cookie consent banners are going to they're very likely to change, or the mechanisms behind it are going to change. The underlying law is not so much going to change, but chances are, and my utter hopes are, that we will be asked for cookie consent a lot less frequently in the foreseeable future. Then there's the Commission's briefing itself says there's a couple of other acts, like the Data Act, the Data Governance Act, the Free Flow of Non-Personal Data Regulation, the EIDAS or EIDAS, I don't even know how to say it in English, and network information security related stuff. Especially the reporting streams, they're going to be consolidated in the sense that, just think of various areas of law where unwanted stuff may happen, and you might have to report them to one authority or the other. And if something happens, especially something major, like you're hacked, you're like a target of a ransomware attack or something, you're very likely to run into a situation where you have to act on several levels and confront or report to several authorities. It could be your banking authority, it can be the data protection authority, it can be this, it could be that. Sometimes you have to report internally as well if you have like a council, like a workers' council, or you probably catch my drift. So that is supposed to be consolidated at least a little. So why should you care? Because the EU, why? So I thought of a couple of scenarios in which you might be affected if you are demo scene close. You can have, if you are a developer, if you're a system administrator, if you're part of a DevOps team, an AI builder maybe, if you're a platform operator, or, and this is last but not least, if you, for example, work for a Microsoft that sells their Microsoft 365 platform, and you're interested in collecting telemetry data that isn't really part of the services that you render, but you say, I want to further develop my platform, my products. What kind of data may I collect on my users to figure out, for example, if a certain translation service is used more often than others, or if certain types of users use this more than that. So if you work in anything that needs reporting, you're likely to at least that's my assumption and my hope. You might find that in the foreseeable future that there will be less duplicate reporting if you don't watch out. I mean, at this point, any company is supposed to have an idea of whom to report what to, but this Digital Omnibus project is supposed to take a little bit of the pain away and just consolidate it so that you have a single or there at least few points of contact for that. And one thing that I'll go into a little bit more detail in a few minutes is also if you want to do AI stuff and you want to do testing, you're more likely to be able to do that without the incredible hurdles that you've had so far. And in my experience, using AI has been quite a challenge in the past years for companies, mainly because, on the one hand, everybody wants to use it, and on the other, you're facing, or you've been faced with so many challenges on a compliance level, trying to figure out what's allowed, what's not, what do you have to do, what kind of documentation do you have to do. Your accountability is huge. But at the same token, not all the levels, the hurdles are actually set. So the AI Act has come with a lot of hurdles, a lot of precaution measures that you have to take. But to some degree, some obligations have not been concretized enough so that you would actually know what to do. So that is taken away a little bit too. So more realistic AI rollout, I wrote because it's some duties that companies or your employer maybe too might have had will be delayed a little bit until I think the latest December of next year, so that we have more time to figure out what actually the duties are that we have to fulfill. And this is more my personal thing. It might affect you too, but there are a couple of boundaries when working with personal data. This is a GDPR topic. We are more likely to. We're not more likely to. The GDPR is more likely to actually mirror reality. So stuff like, what is personal data to begin with? Like, when is a person identifiable with a certain piece of data? What measures do you have to take in order to get this identification? When do you stop? Because at some point, I mean, there are people who argue, and it's debatable, that any piece of data can be related to some natural persons at some point if you just have enough knowledge. So this is sort of what's been happening is the central, the EuGH, how do you say that? CJEU, the central court, the what? The European Court, I don't even know how to say that in English, I used to, CJEU. Well, so there has been some legislation, and the GDPR is now adapted to that. So it's now been court tested, if you will. So a couple of things are are now closer to reality than they used to be, which I personally like a lot. So, let's look at the AI Act. How much time do we have? Okay. At this point, the AI Act is, as I said, it takes a little bit of the pain away, because before if you had high-risk AI, and I'm sorry if this is a little much, if you haven't looked at the AI Act yet, you might not know what high-risk AI means. Let's just say for now that there are certain levels of risk. And pertaining to the risk, there are certain duties that you have to fulfill. And if you use certain high-risk stuff, meaning stuff that's not completely irrelevant, like a chatbot that has no consequence, then at this point you had to fulfill a couple of duties. And at some point you would figure out that it wasn't quite clear what exactly you had to do. You had to register some services to a specific AI office in the EU, and that didn't exist yet, and stuff like that. So the Commission now proposes, as again, it's not yet law yet, but it proposes a delay with a backstop in December 27. But what basically happens is the AI Act's risk-based structure, meaning that is maintained. It means nothing's changed about that. There is stuff that is low risk that you can basically use for whatever. High risk stuff that needs some sort of regulation, and then there's forbidden AI that's just not allowed in the EU at all. That principle stays. But there are going to be some rules on sandboxing and real-world testing. And that is going to be made easier than before. So that's, I think, a good thing for everyone who wants to train their models and do stuff with it. And at this point, as it's not quite concrete yet, I'm just basically throwing an anchor into the future. The hurdle for product teams will be what obligations move into the future, which ones don't, and so what needs to be figured out at some point. I know this is a vague statement because I can't go into much bigger detail at this point, but so what the core statement is, a lot of delays are going to be extended into the future a little. And now, on to GDPR, my favorite topic. The EU Commission calls it clarifications. Here's my attitude about it. It's not clarification, it's finally getting some sanity into it. There were a couple of things that I struggled with ever since the GDPR showed up on stage. And so, well, they call it targeted amendments and clarifications. I don't care what they call it. Again, the notion of what is personal data, identifiable data, is clarified, and it will reflect the central court justice, EU. I should know that. Which basically means if you have adequate means to identify a person on the basis of a certain piece of data, then the data will be personal to you. The same piece of information, same piece of data could be anonymous to other people if they have no way to resolve it to a person, but it will be adequate means, basically. In the data protection bubble, it was kept like that for years anyway, because there was no better way to practically handle it, but now it's in the GDPR too. And now, and this is quite good for everyone who's on a data protection team and who had to pull all-nighters because people were hectic when anything happened. I don't know who of you knows this. Up till now, there's Article 33 and 34 in the GDPR, and they're basically sort of the same token looked from different angles. If a data protection breach happens and it's not completely, or if it's not obvious that the risk for the data subjects is very low, then you had to report to the supervisory authority. And whoever's done that already knows that it can be quite challenging to figure out when do you report, what do you put in. You only have 72 hours to do that after getting knowledge of a breach. And what do you put in if you haven't collected all the data yet? Do you wait a little and then report completely, or do you make an empty, a dummy statement and then say, oh, we'll come up when we know more? And the second one was in 34, when the risk for the data subject was relatively high, not just not low, but high. Then you had to notify the data subjects too. You probably have received emails like that. Oh, like the bad hackers, your data might be compromised, please change your password, stuff like that. So the two hurdles until now have been different, so not low and high. And now with the Digital Omnibus, the first of the two will be raised to the second. So what that essentially means is authorities told everyone to stop reporting anything. They say, don't approach us with just anything, just only if it's important, please. Basically, that's what they said. And another side aspect of it is also the data protection impact assessments. I don't know, hands up if you know what a data protection impact assessment is. Okay, a few. So to make it quick, if you are an organization and you want to process personal data, the processes that you want to do are not just basically irrelevant, no risk for anyone, it's legally not precise, but it's good enough for now, then you have to create a so-called data protection impact assessment. What that basically means is you have to look at what you want to do, you have to look at the risks that might be involved in it, and then at the countermeasures that you have to take or you want to take in order to lower the risk. At the end of this document, your management, whoever is responsible, should say, I have understood and we want to do this. It's basically accountability, it's documentation, it's paperwork. And the Digital Omnibus promises to be more precise on the rules when exactly you have to do that. And I think this is important because there has been a lot of uncertainty as to when you have to create this documentation and when you don't. And this documentation can cause a lot of effort in companies and organizations, now what the EU Commission has said, we'd like to specify a cluster of cases in which you can just go really, really lightweight and not kill yourself over documentation. And for data collectors, meaning if you log identifiers, if you do audit logs, anything DevOps basically, if you're a system administrator, you write logs obviously, and you probably want to know, like, does this affect me? It might come, especially for AI-based stuff, with a new legal basis to collect and process certain information. So if you do any of this, this might make sense to you. Then it might affect you in your daily work. Training corpora. What's that? That's a typo. Training corpora. Training corpora. It sounds like a Cocoon demo, but hint, hint. I just can't find it. What? And I'm sure I made this. The AI didn't do that. It was me. Like, don't mess with AI, man. That's a really dumb sentence. I'm sorry for that. But so what I've been trying to say is there's going to be a new legal or a new cluster of legal basis for using automated data processing that can be a legal basis for you if you write logs, if you take telemetry data as identifiers. Pseudonymization is also going to be regulated differently in the GDPR a little. So if in the future there is a way for you in your work to use pseudonyms as opposed to clear names and stuff, that was always sensible, but now the Digital Omnibus basically says that it's a good idea to use them, and you're safer that way. And this is the page that I already alluded to. If that deals with the hurdle of having to report to the Data Protection Authority that I've already explained. So basically it means before, one more thing. Before, I think it was 72 hours upon knowledge of a data protection breach that you had to report, or there were exemptions, but basically 72 is the number that everyone has in their minds, and I think it's going to be raised to, I think it's 96. But I'm telling this because I can tell you that data protection incidents have a very odd tendency to happen on Friday afternoons. And when you calculate 72 hours from Friday afternoon, it's just like, here goes my weekend, which can be really dumb. So the raising of the deadline to 96 hours might already alleviate the pain here. And now we've talked about some AI stuff, some GDPR stuff, and now let's bring both together. Using AI obviously processes personal data, probably on a larger scale or on a wider horizon than before, because it's really easy to, and arguably even less critical if you drop personal data into an AI that you can control, because AI doesn't judge, or at least if it does, it doesn't matter. But if your Stephanie, colleague in HR, does that personally, it might affect colleagues or employees differently. So what the Commission and what the EU and everyone basically figured out is using AI on personal data is kind of odd, because there is no actual legal basis in the GDPR, because when it was created, AI wasn't a thing. So what they're planning to do is to they're not going to introduce a new legal basis, but they want to make clear that you can use the legitimate interest legal basis that already exists for some AI-related processing. This might go into too much detail if you're not really deeply into data protection yet, but I can tell you that before, if you wanted to get any AI service through your compliance store in the company, you had the problem that whoever was supposed to say, I'm okay with this, had to look for a legal basis, and legitimate interest was always critical, because it's especially difficult to use whenever data might go to a third country like the US, like GDPR standpoint, not third country as in Banana Republic, but let's not go there. But so legitimate interest might be an actual vehicle for you if you want to use personal data, not in all scenarios and not to all extent, but just in principle, it could be at your discretion. However, the Commission has wanted, and is probably going to continue doing that, to change the GDPR as little as possible. The GDPR is apparently very proud of the GDPR, but whoever has seen sessions in which they negotiated those thousands of amendment proposals at the time can sort of relate, because it took a long time. And they probably never want to open that bottle again. So in practice, that basically means if you want to fine-tune, I mean, most of us are not going to train models from scratch, but if you want to fine-tune models, if you want to do some operational analytics on models or on AI output, if you want to implement some parts of like AI workflows into people's everyday work, then before the only chance that you actually had was to get people's consent, and since we're only us and nobody sees me on the internet, I can tell you that I have heard colleagues say that consent is the little asshole of legal bases in data protection, because it is contrary to public belief, consent is very difficult to get and very easy to lose, because it can be withdrawn at any point. And it's just so consent should be, I'm telling you this because I've been there, I've gone through the valley of tears. Consent should be your last resort. If you have nothing else, then you're out of options. But if you are, then don't go into consent. And it's especially difficult in employment context because of subordinacy and stuff. So now, long story short, your legitimate interest might be your legal basis to do some AI-based stuff. But I can tell you that as everything is still in debate, there are a couple of stakeholders in this process that want to oppose this because they obviously think that this is going to open the Pandora's box in AI, obviously. And now on to the part that you all have come here for, probably. There's one thing that a lot of people. Now, first of all, Brussels heard us scream. I have screamed. I can tell you, I've attended webinars. I've attended talks by supervisory authority leaders that talked about cookie banners, and when they were introduced to torture all of us, cookies were the cookie technology was already, I don't know, 20 years old. It was it was your granddad legislation. It was I aged a lot in that year, and when you listen to authority leaders, it was especially horrible because I've heard some people say, yeah, it's that is how it's supposed to be. Like, people have to scream and feel the pain. And I go, for what? Over cookie technology, really? So, apparently, our scream has been loud enough. They want to do something. Now, when I heard that, I thought, yeah, the stupid legislation is going to go away. And it's not as easy, but what's going to happen is, apparently they're not going to change the underlying cause of the cookie banners. But, because that's another long story, the e-privacy story is an entirely different story, full of misunderstandings. So they're not going to change that. But what they want to do is implement a law that practically means that whoever wants to write a cookie or read it needs to listen to certain standardized means of communication, sometimes called PIMS, Personal Information Management Systems. I think in the practical shape and form as in like a browser add-on. I mean, I'm not sure if I think we all have heard of Do Not Track, the browser thing that, I don't know, how old is it, 15 years, something? It's been ages old and everybody ignored it and then it went away. Or maybe it's still there, but it's gone. So now they're coming back with this idea, and they want to make it legal that you can set your cookie privacy preferences in your browser, and whoever wants to do anything with cookies stuff has to ask only once in 6 months. So if you set it to no, they have to listen to that for 6 months. Now, depending on where you go on the internet, that might not at all be a good thing for you. But for most of us, I think, who basically surf the same pages, websites, that might at least give you some sort of 6-month thing. It's like think of it as a half-yearly doctor's appointment that you have to go to. It's kind of like that. So that is roughly where it's going. So I truly hope that most of the cookie banners in my everyday life is going to go away. Yeah. And that if you've happened to come here and you're neither affiliated with telemetry data, you don't write logs, no DevOps team, no AI builder, no nothing, and you're sitting there thinking, what the hell is he talking about? This is the thing that's going to help you, I think, I hope. Let's see. In a year, we might have a beer over it and laugh. Who knows? And here's a little fun fact. This has nothing to do with the GDPR. In 2020, when the pandemic hit, I did a talk about GDPR and privacy stuff, and I asked you at the time, like, what is interesting to you? What do you want to hear about? And people, you screamed at me, those fucking cookies, cookie banners, fucking. And I went, that's not even GDPR. So in a way, it's really ironic that the most relevant part to you is not even data protection. It's an entirely different fundamental law in the EU Charta. It's privacy. It's a different thing. It takes too long to explain here, but it's just another thing that the Digital Omnibus is likely going to change. Now, obviously, just some gossip, if you will. There are some regulators that, again, this is still contested, and the European Data Protection Board and the European Data Protection, I looked this up, Datenschutzbeauftragter. EDPS? Data Protection Officer. Data Protection Officer. Yes, but why EDPS, like protections? Wait, I wrote it down in case I didn't remember. Supervisor. Makes sense, right? So, in a way, the long story short, everyone seems to agree that something had to be done, that the current status sucked, but they can't seem to agree on what exactly has to change, so there's still a lot of debate. Well, it's going to stay interesting, I think. But so, again, 3 takeaways, now 4. The first one is netpoet can't write DO correctly. But other than that, think of the Digital Omnibus more as a refactor. It's not one law that you could look up once it's done, but it's going to trickle down into various areas of law, amongst which will be the GDPR and the AI Act and the e-privacy regulation. For AI, mainly you can take away that AI duties are being delayed because it made no sense to enforce them now to begin with, because they're not concrete enough yet for people to know what exactly they have to do. And roughly, GDPR gets some alterations that I'm personally really happy about. I've been approached outside by someone saying, oh, it's going to weaken the GDPR, and I think it's not strict enough yet. Okay. Let's discuss, I think. But I'm personally quite happy that it will take the GDPR at least closer to my everyday life, in my professional life, because I think it also it enables or it helps us to maintain a certain calmness, even if unexpected stuff happens. Nobody has to become really hectic and do crazy stuff. And, stay calm, let's look at stuff and figure stuff out. Questions or discussions? Throw attitude at me. I think there's a hand raised at the back. Sorry. Sorry. I didn't mean for him to take it away from you.
Yeah. So you said earlier that the reporting duties around the GDPR are made easier for
organizations.
Low impact cases, basically. But I assume the general duty that you have to keep up to date documentation.
Speak up, please, because I cannot hear you. Sorry.
I assume that general duties in the GDPR that you have to keep up to date documentation of your processes in the back end are not affected by that, correctly?
Not to my knowledge, no.
Thank you.
But then again, also, if you allude to Europa's, the Register of Processing Activities, that is something that in theory you have to do, but it was largely, or it has been largely, the organization's responsibility to figure out how to do it. So, yeah, but not to my knowledge, no.
So, what do you think of the opinion that Digital Omnibus will shoot data protection legislation in the kneecap in the name of capitalism? Because that's the opinion that I've heard before at seminars that I've attended.
Let me get this, let me understand. So what I think of the opinion that the Digital Omnibus is going to do what with capitalism?
Well, it's kind of going to undermine the principal idea before GDPR. It's going to make using AI easier, as you said, making those pilot projects.
Probably, yes.
Yes, and for some sectors like public health care and stuff like that, there's a ton of different AI programs currently in operation already, and it's going to be made even easier to use everyone's personal health data for this purpose. And it's not my personal opinion, but just if someone...
But what is the opinion? I just haven't understood. So, okay, so I understand that, yes, it'll make using AI easier.
It's going to make business easier. That's the main point.
It's going to make business easier.
Yes, and that's why the Digital Omnibus is there. It's going to simplify the legislation so that businesses can use data more freely.
I would think it's a consequence. I'm not sure it's intended probably in the sense that companies say there's stuff that we want to do, some stuff we have to do. If you, for example, and I'm just making this up because I don't know specifics about it, but I can imagine that, for example, in the public health sector, insurances say, why don't we cut a lot of the costs that are raising and making stuff more and more expensive by using automated measures of, let's say, finding breast cancer. Is that going to help their business? Absolutely. Is it intended? I would think the intention depends on whom you ask. The EU Commission probably takes into consideration that companies show up. I mean, everybody calls it lobby work, and it is. But what lobby work is interested parties, stakeholders, showing up and saying, hey, our situation is this, and this is what we'd like. So, is it related? Does it make business easier? Sure. Does this affect capitalism? Absolutely. Because basically what we have is, what we live in is capitalism. Yeah. Money, sure. So I'm sure a lot of interested parties have been talking to the EU's organs, and yeah, I don't think that's the only reason. I think personally, I think it's sensible to make way to stuff that, and health data is part of it. You're right. It makes sense for certain types of data to be processed via AI more easily. And here's just a thought. I know this goes this is a rabbit hole all in itself, but if you have natural persons process your health data, then I think it largely depends on whether you trust them, whether you like them doing that, especially if you see a doctor or a nurse or this or that. Is it more or less critical if your health data is processed by an AI? I know that I know there's a reflex to say, "Oh, my data in the world," and I understand because it's different. I understand. I think, but to some degree, I would even say it's less critical because if you can control it, if it doesn't go anywhere, it just finds a pattern and returns whether you have breast cancer or not.
Okay, thank you.
Sure.
I have a question. Does this regulation is related to private persons or businesses? Who is obligated? There are some exceptions, etc.
It largely targets organizations, not private persons, meaning especially consumers. But if you are a natural person and you build an AI system, then it affects you too. So most of the stuff will be targeted towards companies, organizations, and not to natural persons. But you might face it when you offer an AI service all by yourself. All righty. I'll be here. Thank you very much. I'm happy for feedback again. Approach me and say, "Oh, this sucked. Like, why can't you go into more detail?" Or, "Hey, I'm glad you gave me an overview." Something like that. Just feel free to hit me up. Let's go party.